This video is an overview of Topic 6 of the RE5 exams. The title for Topic 6 is Comply with the requirements of the FIC Act and Money Laundering and Terrorist Financing Control Regulations. Definition of money laundering. Money laundering or money laundering activity means an activity which has or is likely to have the effect of concealing or disguising the nature, source, location, disposition or movement of the proceeds of unlawful activities or any interest which anyone has in such proceeds, and includes any activity which constitutes an offence in terms of Section 64 of the FIC Act or Section 4, 5 or 6 of the Prevention of Organised Crime Act, POCA. What is a money laundering activity? Money laundering is the process of manipulating the proceeds of crime in order to conceal the nature of its true source. Money that started out dirty will end up clean, and any act in connection with any proceeds of crime, whether it is in the form of money or property or any other form, can constitute a laundering offense. Money laundering is a three-stage process. The three stages of money laundering. The first stage is placement, where the origin of illegal money is usually mixed with the origin of legitimate money. The proceeds of unlawful business are in the form of cash, making it relatively simple to get the illegal money back into the financial system by mixing it with the proceeds of a cash business. This dirty money is therefore disguised and the illegal funds avoid detection. A further aim is to convert the nature of the profits, usually cash, into some other asset, such as property, or certain financial instruments, such as life assurance investments or traveler's checks. In the second stage, money launderers try to achieve four main objectives. Disguise the ownership. Disguise the origin. Disguise the audit trail. And disguise the profit and source of crime. This is achieved by conducting layers of complicated financial transactions, usually using electronic transactions. Transactions include dealing with shares, commodity and futures brokers. The third stage consists of a series of more transactions, designed to make the funds available to the criminal again. This is achieved by accessing the funds and using it for legitimate purposes. The funds are now fully integrated into the financial system. The concept of money laundering and unlawful activities. Money laundering is one of the biggest challenges facing governments throughout the world today, as a result of terrorism and organized crime. Both are real threats to civilization as we know it. Money laundering has been used by terrorist organizations to fund their activities. The original purely criminal focus of anti-money laundering measures has been broadened in recent years to cover terrorism and organized crime as well. In South Africa, this led to the implementation of the Prevention of Organised Crime Act. POCA, the Financial Intelligence Center Act, FICA, and the Protection of Constitutional Democracy Against Terrorism and Related Activities Act, known by its acronym as POCDATARA. Unlawful activities. What are unlawful activities? Any conduct that constitutes a crime or which contravenes any law, whether the conduct occurred before or after the commencement of the South African legislation, or in SA or elsewhere, constitutes unlawful activity. Examples: tax evasion, drug trafficking, theft, robbery, fraud, abduction, extortion. Possible indicators of a suspicious transaction. The following are examples of possible suspicious or unusual transactions. They may be perfectly legitimate, but they are often used to cover money laundering. Payments to be made to third parties. Transfer of funds to other product providers. Constant movement of money among different business entities. Transactions that have no apparent business purpose. Transactions involving large cash amounts. Surrendering of policies and second-hand, traded, policies shortly after they have been purchased. Loans against new generation products. Loans can then be repaid with dirty money in order to clean the money. The money laundering legislation. The first thing to understand about money laundering legislation is that it does not act upon the crime itself that has brought about illegal money, for example drug dealing. It deals with the proceeds of that crime. The three main laws dealing with money laundering in South Africa, in chronological order, are the Prevention of Organised Crime Act 1989, 121 of 1998, POCA, the Financial Intelligence Center Act, 38 of 2001, FICA, and the Protection of Constitutional Democracy Against Terrorism and Related Activities Act, 2004, POCDATARA. The Financial Intelligence Center Act, FICA. FICA's purpose is to combat money laundering activities and the financing of terrorist and related activities. The 2001 FICA Act creates the requirements to ensure that money laundering is controlled. It is aimed at identifying suspicious transactions so that the people who engage in money laundering activities can be charged under POCA. Suspicious transactions must be reported under FICA, which now provides the infrastructure to curb money laundering activities. The Act also requires accountable institutions that could serve as a conduit for dirty money to comply with certain legal duties relating to combating money laundering. Financial Intelligence Center. The principal objective of the FIC is to assist in the identification of the proceeds of unlawful activities and the combating of money laundering activities. All accountable institutions are required by the Act to report all information regarding money laundering activities to the FIC, where it is handed over to the appropriate authorities for further recourse. Other objectives of the Center include to make information collected by it available to investigating authorities, the intelligence services and the South African Revenue Services to facilitate the administration and enforcement of the laws of the Republic. To exchange information with similar bodies in other countries regarding money laundering activities and similar offences. Money Laundering Advisory Council. Section 17 of FICA establishes the Money Laundering Advisory Council, an advisory body on combating money laundering. It advises the Minister of Finance on policies and best practices to combat money laundering and to identify the proceeds of unlawful activities. It also acts as a forum in which associations representing categories of accountable institutions, organs of state and supervisory bodies that report to the Financial Intelligence Center can consult one another. The Council should also advise the Financial Intelligence Center on the performance of its functions. In simple terms, FICA requires the creation of a paper trail, with detailed records of the origins of money placed with an accountable institution and the people involved. Internationally, this paper trail makes it more difficult to launder money. The requirements specific to an FSP prescribed by the FIC Act. The impact of FICA on FSPs. The FICA creates 4 money laundering control obligations for all accountable institutions as follows. Duty to identify and verify clients. Duty to keep records of business relationships and transactions. Reporting duties and obligations to give and allow access to information. Adoption of measures designed to promote compliance by accountable institutions. In terms of these requirements, an FSP who is an accountable institution, as defined in the FICA, must have in place all the necessary policies, procedures and systems to ensure full compliance with that Act and other applicable anti-money laundering or terrorist financing legislation. Identification of new clients. Section 21.1 of the FICA requires accountable institutions to identify new clients and verify their particulars before any transaction may be concluded or any business relationship is established with them unless they qualify for Exemption 2. Exemption 2 stipulates that an accountable institution may accept a mandate from a prospective client and proceed to establish a business relationship or conclude a single transaction with that client. Verification of new clients. The Money Laundering Control Regulations prescribe the identification and verification requirements for clients of accountable institutions, ranging from SA citizens and residents, foreign nationals, corporations, South African companies, close foreign companies, partnerships and trusts. The information obtained from legal persons such as companies, close corporations, and trusts must be verified by comparing it against the registration documents of these legal entities. The identification procedures in respect of the legal persons referred to above must also be extended to directors, shareholders, members and trustees. Documents serving to confirm their authority to act on behalf of these legal entities must also be obtained. Identification and verification of existing clients. Section 21(2) of the FICA requires a similar process for existing clients as for new clients. It also states that if an accountable institution had established a business relationship with a client before the FICA took effect, it may not conclude further transactions in the course of that business relationship, unless prescribed steps are taken to ensure the identities of the clients are established and verified. A period of time was granted for compliance with this requirement. Additional measures when a person represents or acts on authority of another. Regulation 17 states that if a person wants to establish a business relationship or to conclude a single transaction with an accountable institution on behalf of another person, the accountable institution must, in addition to the normal identification and verification requirements, obtain from that person information which provides proof of that person's authority to act on behalf of the client. Information that can be obtained includes mandate, power of attorney, etc. Verification in the absence of a contact person. Non-face-to-face clients. Regulation 18 stipulates that if the accountable institution obtained identification and verification information from a natural or legal person without contact in person with such a natural person or representative of that legal person, the accountable institution must take reasonable steps to establish the existence and verify the identity of that natural person or legal person. Authorized FSPs are encouraged to establish procedures for dealing with non-face-to-face clients and must incorporate them into their main client acceptance procedure manual. Documents required for identification and verification. For a natural person, RSA citizen, a copy of the ID document will serve as verification of his identity. Residential address verification can be obtained from a utility bill, a bank statement from another bank reflecting the name and address, a municipal rates and taxes invoice, a telephone or cell phone account reflecting the name and residential address of the person, etc. A foreign national may be identified from an identity document or passport, in addition to a letter of confirmation from a person in authority, for example from the relevant embassy, which confirms authenticity of that person's identity document. For a private company the following may be used. Registered name and registration number, address, registered trade name and address, documentation to verify tax and VAT number, any SARS document, personal details of manager, CEO or both, details of shareholders holding 25% or more voting rights, mandate authorizing person acting on behalf of company and entering into business relationships, most recent version of Certificate of Incorporation, CM1, Notice of Registration of Office and Postal Address, CM22. For a company listed on the JSE, only a registration number and the name of the company are required. For a close corporation the following may be required. Registered name and registration number, address, registered trade name and address, documentation to verify tax and VAT number, most recent version of the founding statement, CK1, Notice of Registration of Office and Postal Address, CM22, the Members' Agreement, a resolution authorizing the person to act, personal details of each member of the CC. For a trust the following are required. The identifying name and number of the trust, the address of the master where it is registered, the trust deed or other founding document, letter of authority from the master of the High Court in SAW, the income tax registration number, trustee's resolution authorizing person to act, personal details of each trustee, each beneficiary referred to by name in the trust deed, the founder and the person authorized to act. Exemptions relating to identification and verification. Exemptions. FICA provides for certain exemptions in terms of circumstances where accountable institutions do not have to identify and verify clients. There are general exemptions that apply to certain accountable institutions. Where a business relationship, single transaction is established or concluded with a second accountable institution after the primary institution has identified and verified the client. There are also specific exemptions. Any long-term insurance policy which provides benefits only upon the death, disability, sickness or injury of the life insured. Any long-term insurance policy, unit trust or linked product in respect of which recurring premiums contributions are paid, which will amount to an annual total not exceeding $25,000, subject to the condition that the client will have to be identified and verified if the recurring premium is increased so that the R25000P.A. is exceeded. The policy or investment is surrendered or liquidated within 3 years. A loan is granted against the policy within 3 years. Exemptions relating to identification and verification continued. Specific exemptions. Any long-term insurance policy, unit trust or linked product in respect of which a single premium, contribution not exceeding $50,000 is payable, subject to the condition that the client will have to be identified and verified if the policy investment is surrendered, liquidated within 3 years after its commencement. A loan is granted against the security of such a policy within 3 years after its commencement. Any other long-term policy where the surrender value of the policy does not exceed 20% of the value of the premiums paid in respect of the policy within the first 3 years of the policy. How the FIC Act impacts a representative's interaction with a client. The impact of FICA on financial services providers and representatives, in their role as accountable institutions, is determined by the additional duties that it imposes on them. The main duties of accountable institutions, including those that are FSPs and representatives, as described in FICA, include identifying and verifying clients, reporting suspicious transactions, keeping records, training staff, formulating and implementing internal rules, reporting cash transactions. The Act requires accountable institutions and reporting institutions, motor vehicle and Kruger-Rand dealers, to report cash transactions above the prescribed limit, as at 2011. $24,999.99 or an aggregate of smaller amounts which, combined, add up to this amount if it appears that the transactions involving these amounts are linked to be considered fractions of one transaction. This reporting duty is applicable where the accountable or reportable institution receives the cash amount from a client, as well as where the accountable or reportable institution pays a cash amount above the prescribed limit to the client. Processes in place to ensure that employees receive training. The two duties that FICA imposes on an FSP, as an accountable institution, relating to its employees, are the training of staff and the formulation and implementation of internal rules. 1. Training staff. FSPs have to ensure that staff is suitably trained. In addition, they have to put in place a reporting of suspicious transactions procedure. Harsh penalties are set out, either for the individual who does not comply, or for the organization that does not comply, namely maximum imprisonment for a period not exceeding 5 years or a fine not exceeding R10,000,000. 2. Formulating and implementing internal rules. The Act requires that the FSP formulate and implement internal rules relating to the identification and verification of a person's identity, the record-keeping requirements prescribed in the Act, steps to be taken to decide whether a transaction is reportable or not. In addition to the above, an FSP, as an accountable institution, also needs to be aware of the obligations created in the following. The common law. Industry-specific and sector-specific legislation. The 40 FATF recommendations, as changed from time to time. International best practices within the industry. Accountable institutions. An FSP who is an accountable institution as defined in the FICA, must have in place all the necessary policies, procedures and systems to ensure full compliance with that Act and other applicable anti-money laundering or terrorist financing legislation. The FIC Act requires accountable institutions to verify client details and report suspicious transactions. List of accountable institutions. For our purposes, the following institutions are included in Schedule 1 of the Act: Financial Intelligence Center ACT, 2001 Schedule 1. List of accountable institutions. A practitioner who practices as defined in Section 1 of the Attorneys Act, 1979. Act 53 of 1979. A board of executors or a trust company or any other person that invests, keeps in safe custody, controls or administers trust property within the meaning of the Trust Property Control Act, 1988. Act 57 of 1988. An estate agent as defined in the Estate Agency Affairs Act, 1976. Act 112 of 1976. An authorized user of an exchange as defined in the Securities Services Act, 2004. Act 36 of 2004. A manager registered in terms of the Collective Investment Schemes Control Act, 2002. Act 45 of 2002. but excludes managers who only conduct business in Part 6 of the Collective Investment Schemes Control Act. Act 45 of 2002. A person who carries on the business of a bank, as defined in the Banks Act, 1990, Act 94 of 1990. A mutual bank as defined in the Mutual Banks Act, 1993, Act 124 of 1993. A person who carries on a long-term insurance business, as defined in the Long-Term Insurance Act, 1998. Act 52 of 1998. A person who carries on a business in respect of which a gambling license is required to be issued by a provincial licensing authority. List of accountable institutions continued. A person who carries on the business of dealing in foreign exchange. A person who carries on the business of lending money against the security of securities. A person who carries on the business of a financial services provider requiring authorization in terms of the Financial Advisory and Intermediary Services Act, 2002, Act 37 of 2002. To provide advice and intermediary services in respect of the investment of any financial product, but excluding a short-term insurance contract or policy referred to in the Short-Term Insurance Act. 1998, Act 53 of 1998, and a health service benefit provided by a medical scheme as defined in Section 1(1) of the Medical Schemes Act, 1998, Act 131 of 1998. A person who issues, sells or redeems travelers' checks, money orders or similar instruments. A person who carries on the business of a money remitter. Reporting institutions. The FIC Act also requires reporting institutions to verify client details and report suspicious transactions. According to Schedule 3 of the Act, the following are seen as reporting institutions. A person who carries on the business of dealing in motor vehicles. A person who carries on the business of dealing in Kruger-Rands. It is therefore imperative that FSPs have adequate staff training in place and have proper systems and procedures which assist them in complying with the FIC Act requirement to comply with the FICA. Banks and insurance companies, for instance, are regarded as accountable institutions in terms of the FICA. The recording function. FICA requires the following records to be kept. The identity of the client. The identity and authority of a person acting on behalf of a client. The identity and authority of a client acting on behalf of another person. The manner in which the identity was established. The nature of the business relationship or transaction. The name of the person who obtained the information on behalf of the accountable institution. Documents used to identify and verify the client or the other person. Accessibility of information. An authorized representative of the Financial Intelligence Center has access to records kept by an accountable institution during ordinary working hours and may examine, make extracts or make copies of such records. Where such records are not available to the general public, a warrant issued by a judge or magistrate of the region in which the accountable institution conducts business is required by the representative of the FIC. Such a warrant will only be issued if there are reasonable grounds to believe that the records will assist in identifying the proceeds of unlawful activities. The role of the money laundering officer. The employees of the institution will report suspicious or unusual transactions to the money laundering reporting officer in that institution. The procedure for making the report must be laid down in the internal rules that the institution has put in place, to ensure compliance with FICA. The reporting officer will investigate the transaction to determine whether in fact it was suspicious and/or unusual. If so, the Money Laundering Reporting Officer must report the transaction to the Financial Intelligence Center within 15 working days of learning of it or from when the suspicion arose. The FIC may ask for additional information on the matter. The consequences of non-compliance. In terms of FICA, penalties for offences range from 5 years imprisonment or a fine of R10 million, to 15 years imprisonment or a fine of R100 million. Offences subject to the penalties include, amongst others, failure to identify persons, R100 million or 15 years imprisonment, failure to keep records, R100 million or 15 years imprisonment, destroying or tampering with records, R100 million or 15 years imprisonment, failure to give assistance to the FIC, R100 million or 15 years imprisonment, failure to report cash transactions as prescribed, R100 million or 15 years imprisonment, failure to report suspicious or unusual transactions, R100 million or 15 years imprisonment, failure to train staff or to appoint a compliance officer, or to implement internal rules, R10 million or 5 years imprisonment. Penalties. Section 68 prescribes the penalties for persons convicted of offences as described above. Depending on the offence, the penalties range from imprisonment for a period not exceeding 5 years to a period not exceeding 15 years or to a fine not exceeding R10 million to a fine not exceeding R100 million. An accountable institution which fails to provide this assistance is guilty of an offence, punishable with imprisonment for a period not exceeding 15 years, or a fine not exceeding R100 million. The offences include establishing or maintaining a business relationship, or entering into a single transaction with a client who is using a false name, failing to obtain particulars or verify particulars with regard to natural persons who are South African citizens and residents, natural persons who are foreign nationals, legal persons who are close corporations and South African companies, legal persons who are foreign companies, legal persons who are other legal persons, partnerships, trusts, and persons who are acting on the authority of another. Failing to take reasonable steps to verify information obtained about a natural person or a representative of a legal person, partnership or trust when there has been no contact in person with the natural person or representative of a legal person. Failing to take reasonable steps to maintain the correctness of particulars. Failing to inform the FIC of particulars of third parties. Failing to send in a report on a suspicious or unusual transaction. And failing to develop internal rules. Penalties continued. Should a person contravene any one of the following requirements under the FICA regulations, and be convicted of an offence, such person may be liable to imprisonment for a period not exceeding 6 months or to a fine not exceeding R100,000. The Prevention of Organized Crime Act. POCA. The purpose of POCA: to introduce measures to combat organized crime, money laundering and criminal gang activities. Objectives of POCA: to criminalize racketeering and offenses relating to activities of criminal gangs. To criminalize money laundering and a number of serious offenses in respect of laundering and racketeering. To create a general reporting obligation for businesses coming into possession of suspicious property. To create a mechanism for criminal confiscation of proceeds of crime and for civil forfeiture of proceeds. Money laundering offenses under POCA. POCA creates the following money laundering offenses. Offenses involving proceeds of all forms of crime. Offenses involving proceeds of a pattern of racketeering. Receiving or keeping property derived from racketeering, swindling, committing fraud, and using or investing any part of that property in the acquisition of any interest in, or the establishment or operation or activities of, any enterprise. Receiving property from an enterprise, knowing, or should have known, that the property results from racketeering. Penalties can be as stiff as a maximum fine of R100 million or imprisonment for 30 years. The protection of constitutional democracy. Against Terrorism and Related Activities Act. POCDATARA. Money laundering has also been used by terrorist organizations to fund their activities. The original purely criminal focus of anti-money laundering measures has been broadened in recent years to cover this as well. In South Africa, this led to the 2004 Protection of Constitutional Democracy Against Terrorism and Related Activities Act, known as POCDATARA. It introduced a new Section 28A of FICA, which requires the reporting of any property associated with terrorist and related activity to the Financial Intelligence Center. The aim of POCDATARA is therefore to introduce an obligation to report certain offences linked to terrorist activities, including terrorist financing.